estate, and the identity of the manager is disclosed. And you usually do this by forming a separate Delaware LLC to act as the manager, and you do not register the manager LLC in your state. One other important point that I forgot to mention, but it's very important. Let's say that the client has a limited partnership. Same charging order protection as LLCs. We're discussing LLCs, but as I mentioned, same rules apply to limited partnerships. With a limited partnership, you have a general partner. And as you're probably aware, the general partner of a limited partnership has unlimited liability exposure, meaning if the limited partnership gets sued, that plaintiff can go after the general partner and go after the assets of the general partner. So what do we do most of the time to prevent that from happening? Well, we form some sort of a legal entity to be the general partner and to block off that liability. What I see a lot of attorneys and a lot of accountants do is to say that the general partner of a limited partnership should be a corporation. I think that in a lot of cases that is malpractice. Why? Let's say that our Dr. Brown owns some valuable assets through a limited partnership. He is the limited partner, and he owns the corporation that is the general partner. Fairly typical structure. Dr. Brown gets sued. Creditor starts looking for his assets. You own a limited partnership interest. We'll get a charging order against this limited partnership interest. And Dr. Brown is happy. Fine, get your charging order. You'll never see a dime of cash. And then the creditor says, well, what else do you own? Well, how about the stock of the corporation that is the general partner? As you remember, we discussed they can take the stock away from Dr. Brown. And once the creditors own this corporation that is the general partner, what can they do? As the general partner, they can now start making distributions and intercept them with their charging order. So you always want to have a general partner entity be a limited liability company so that the general partner entity cannot be taken away from Dr. Brown. Corporations will not work. Okay, we are moving past legal entities and we are moving on to trusts. So very briefly, to kind of catch everyone up, for those of you who are not estate planning attorneys, what is a trust? There's a lot of confusion on the subject. A lot of people believe that a trust is equivalent to a legal entity or it's some sort of a person, legally speaking. A trust is nothing more than a contract. It is an agreement between the person who set up the trust, who we call the settlor, or the trustor in some states, and the trustee of the trust. It's just a contract between the settlor and the trustee. That's it. An agreement, nothing more. Which is a very important point to keep in mind. Because from an asset protection standpoint, the fact that it's nothing more than a contract allows us to do a lot of things and allows us to do them with a lot of flexibility. And we'll come back to that in a little bit. From an asset protection standpoint, the most beneficial feature of a trust is the fact that the trust really splits the ownership of any asset that you transfer to the trust. When you transfer an asset to the trustee of the trust, the trustee is the one who now holds legal title to the asset. So for example, if I transfer my residence to, let's say, a living trust, how will the title to my residence read? It will read, Joe Schmo, trustee of such and such a trust. Okay? It is a legal title is held in the name of the trustee. But the trustee does not own this asset for himself. It's not really his, right? The trustee owns it for the benefit of the beneficiaries. So it's the beneficiaries who hold the so-called equitable interest in this asset. So we split those two, the legal title from the equitable interest in the asset. And by doing that, we can get a lot of protection for our assets. And if you think about it, it is really exactly what we use LLCs for and limited partnerships, right? With an LLC, we transfer the asset to the LLC. The client no longer owns that asset. It's now owned by the limited liability company, but the client can still be the manager of the LLC and still exercise full control over that asset. Well, that is exactly what we are aiming to do with the trust. We want to transfer the asset to the trustee of the trust, but maybe by picking the right trustee, continue to exercise control, and maybe we can keep our family, kids, spouses, whoever, as the beneficiaries of the trust. So how does it work? We're on slide number 11. From an asset protection standpoint, the trust has to be irrevocable. Why is that? The most commonly drafted trust is the so-called revocable living trust. And the living trust gives you no asset protection because it is revocable. What does it mean, revocable? Revocable means that somebody, usually the person who set up the trust, retained the ability to revoke it. Revoke it means we terminate the trust and the assets out of the trust come back into our name. So think about it. Our client has transferred assets into a trust but retained the ability to simply take them back. Whenever a person has the ability to exercise some sort of control over a trust, and he can exercise that control for his own benefit, he can be forced to do so. Okay? Our client has the ability to revoke the trust, and if he revokes the trust, who benefits from it? He does, because the assets come back to him. He is the settlor, the trustor of this trust. So he has retained control over the trust. He can exercise it for his own benefit. He can be forced to exercise it. In most states, the settlor of a living trust will not be forced to actually revoke the trust. The assets go back to the settlor, and then the creditor goes after those assets. In most states, creditors are allowed to go directly after the assets held by a living trust, by an intra vivos revocable trust. Okay? So there is no protection there. The first rule of any good asset protection trust is that the trust must be irrevocable. So let's say we set up a trust that's irrevocable, for the benefit of, let's say, our kids. We need to make sure that at some point in time the kids get the money out of the trust. So the trust provides that whenever the kids need to get the money out of the trust, they just go to the trustee and say, hey, Uncle Bill, we need some money. Give us the money. Well, what have you done? You have given the beneficiary the ability to exercise some control over the trust for their own benefit, which means that if tomorrow the beneficiary is being sued, the assets in the trust are exposed to the beneficiary's plaintiff, which means that we do not want to give the beneficiary any sort of a demand power. We want to have what's called the Spendthrift clause in the trust. The Spendthrift provision in the trust provides that the beneficiary is not allowed from demanding a distribution, from anticipating a distribution, from assigning his interest in the trust. Okay, that is the Spendthrift clause. The beneficiary cannot demand a distribution. Well, let's say we set up a trust, and it's irrevocable, and the beneficiary does not have the ability to demand a distribution. We still want to make sure that at some point in time, the beneficiary will be able to get the benefit out of the trust, get the assets out of the trust. So the trust, let's say, provides that every June 1st, the trustee must distribute, $100,000 to this beneficiary. Let's say that it's December, and the beneficiary goes to a holiday party, he drinks a little bit, gets into a car accident. Plaintiff is now suing the beneficiary. It's May, the lawsuit is concluded, judgment for the plaintiff. The trustee knows that on June 1st, he has to distribute $100,000 to this beneficiary. The trustee also knows that if he makes that distribution, the money is going to go to the beneficiary's creditors. What should the trustee do? Well, it's very simple. The trustee entered into a contract. He entered into this trust agreement. And this trust agreement obligates the trustee to follow the provisions of the trust. And if the trust agreement provides that on June 1st you make this distribution, he has to make that distribution, even if he knows that the money will go to the beneficiary's creditors. Which means that we do not want to have these mandatory distribution provisions in the trust, because we cannot anticipate everything that will happen. We want to be able to give the trustee of the trust as much discretion as possible.